When you need a lawyer, how do you find the right one? Contact the Chicago Bar Association.
Whether you've been injured or need a will prepared, whether you're buying a home or starting a business, having the right lawyer is essential. The Chicago Bar Association have lawyers who practice in most areas of law and speak a variety of languages.
Don't leave it to chance. Get a referral to a screened, experienced lawyer. Visit chicagobar.org or call 312-554-2001. The Chicago Bar Association. Se habla español.
Welcome to You and the Law, a Chicago Bar Association production that provides information on a variety of legal and policy matters of public interest. I'm Mike Al-Kharaki, a partner at the plaintiff's personal injury firm Leahy Hosty Al-Kharaki, an adjunct professor of advocacy at Loyola Law here in the city, and a member of the Chicago Bar Association. On today's show, we're going to provide an overview of the U.S. Supreme Court and what it's like to advocate in the court. This is going to be an intro and companion program to a forthcoming show that will address the anticipated Dobbs opinion and how that is likely to affect Illinois residents. We're lucky to have with us two great guests. Michael Rathsack is a well-known appellate litigator who runs the law office of Michael W. Rathsack and has, fair to say, probably more or less seen it all. And Jonathan Amarillo is a partner at the Taft Law Firm who co-chairs the firm's appellate practice group and recently had the opportunity to advocate in the United States Supreme Court. Welcome to the show.
Good morning.
Thanks. Very brief introduction. John and Mike. John, you can go first if you can give us a little bit more background and your experience in the nature of your practice.
Mike, as you said, I'm an appellate lawyer, so my job is Mike's job is to take over a case after it's been heard by a judge or a jury and take it up to a court of review to see if everything was done correctly, essentially. And that's more or less a job description, right?
That's it. Somebody compared it to coming to the scene of battle afterwards and trying to decide who's going to live and who's going to die and trying to preserve things. We're really not part of the fight in the trial court. And that's kind of the segue we were talking about. People have always asked both of us when we say we're appellate lawyers, so what is that?
Yeah.
And a lot of people don't run into it. You try your case at the trial court level, you get a decision. The appellate court and then the Supreme Courts of the states and the United States basically are like instant replay, I would call it, video replay. The courts take a look at what happened in the trial court and decide if there was a mistake made or decided if some law wasn't enforced properly, and they'll reverse it and give you a new trial. That's really what we do.
Yeah.
Great, thanks. So I'm going to start with some very basic questions, and we'll get into a little bit more detail. But can you share a little bit, and either one of you can take this, a little bit of the difference between, of course, you've got, the state court system and the federal court system, and those can both culminate potentially in a United States Supreme Court case. So can you very briefly kind of discuss a little bit of the difference between the state and federal courts and how cases might get there?
Well, on the state level, it varies greatly from state to state. In Illinois, we have a unitary court structure the way the federal courts have. So there's trial court, intermediate appellate court, and Supreme Court. Again, federal courts are the exact same way. Some states bifurcate their court structure so that there's a criminal lane and a civil law lane, and there's a few states that do it even more differently than that. But Mike?
That's really the description. The state courts are just, because there's more, they're just bigger. There's more of them because you have a lot of state issues. And the federal courts are limited pretty much to federal issues, federal law issues, federal constitutional issues. So they're much smaller. And the appellate courts, the federal appellate courts, compared to the state appellate courts, are very compact.
Right.
And taking a step, a very, very basic question, the United States Supreme Court has its foundation in the Constitution, Article 3, Section 1, I believe. You probably know a little bit more about the history just from talking earlier. I mean, it sounds like you're both kind of historians of the United States Supreme Court. And can you provide, John, I know you had a little bit of a story before, you had some comments on that. Can you provide a little bit of the basis for the Supreme Court, its structure, those sorts of things?
Sure. There's very little in the Constitution itself, Article 3, as you said, about the Supreme Court, even what the Supreme Court is supposed to do. Most of that was fleshed out in the Judiciary Act of 1789, which really set up the court structure, how many justices would be on the court, what kind of cases the court could hear. The Constitution says very little about that. And there have been one or two other, I think, Judiciary Acts since then, but that was really the genesis, 1789.
It's sort of odd, they were worried about setting up who's going to enact the laws. The founders were worried about how we're going to run the country, and almost like, well, we need to have somebody to be an umpire, so we'll call it the U.S. Supreme Court. And that's pretty much where it stopped. The rest of it is really shaped so much by what Congress does and what people vote to have their legislators do.
It was, in some ways, an afterthought for the Founding Fathers. It's Article 3 for a reason. Article 1 was the legislature because they thought that's the most important topic. Article 2 for the executive. They thought that came after the legislature. And third and last was the judiciary. Although, since then, I would say the executive branch has definitely eclipsed the legislative branch in importance.
Yeah. So there has, I think it seems like, fairly recently, in recent years, there's been, I would say, pronounced attention on the manner in which Supreme Court justices are nominated. And can you provide a little bit of background on the procedure for somebody getting on to the United States Supreme Court?
If I can just step back, we'd mentioned it earlier a little bit. This wasn't considered a plum job when the country started. There weren't many of them. They rode the circuit, literally. I mean, if you were a U.S. Supreme Court judge, you had 2 or 3 states, and you got on horseback, and you went from place to place and worked. People didn't necessarily want the job, so it wasn't as if people were angry to get it. And it's a life tenure position, but that wasn't so important. Even early 1800s, people got sick and died. They just didn't last. Things changed as time went on, and people wanted the job. Nonetheless, the selection process was just this. It's still the same as it always has been. Somebody nominates you. You have to get the attention of somebody to nominate you. The Senate considers you, and you need 50 votes from the Senate plus 1. And you become a U.S. Supreme Court judge.
And that's the advice and consent discussion, right?
Yeah, and that's what's become so critical is the legislature is separated into the left and the right. That didn't used to be the case, I don't think, did it?
Not until the nomination of Judge Bork, and it's been highly politicized in most cases since then.
So that kind of brings us to our next topic, which we can spend a little bit of time on, because obviously we want to get to what it's like to actually advocate there and the broader role of the court. But can you discuss a little bit of the concept of judicial independence, what that means, why it's important, and how that might be difficult at times?
The best way I can describe that is a friend of mine sitting in the state courts was faced years and years ago with an abortion issue, and he happens to be a devout Catholic and would not believe it, but judicial independence means that he was supposed to follow the law, not his personal beliefs, and he did that. I know this because I know him, and I know what the ruling was. That's always been the goal for the judges. You're not supposed to have your personal beliefs come into play when I'm ruling for you or against you. And I think for many years, it's hard. For many years, I think that was the case. I might be naive.
Like in terms of judges not voting their beliefs?
Yeah,
I'd say it varies on a case-by-case basis.
It does. It's hard to say. When the Dred Scott decision, which
I was just thinking of Taney.
Years ago, black people were chattel was basically the holding of the court. It's possible that judge really believed he was doing the right thing, but it's hard to believe he didn't also have a real personal predilection in that favor to come out with that
slave-owning judge.
Slave-owning judge. And my opinion is, for many years, up until the 60s, I thought the judges, as a group, probably acted more independently. There may have been an individual, but there's 9 of them. So even if I'm pushing a personal issue, I've got to convince 4 others that my personal issue is also the law. I think until you get everybody on the court of the same mindset, I think it's hard to do.
I think that's right. The goal, as Chief Justice Roberts put it at his confirmation hearing, was for judges just to be calling balls and strikes and not to be letting their personal beliefs interfere with their interpretation of the law. The daily reality of that, I would say, varies from judge to judge and justice to justice.
Sure, and certainly that seems to be a major component of the concept of judicial independence, the idea that the justice will follow the law and not his or her personal beliefs. There's also, of course, the more broader issue of the independence of the judiciary, right? Especially in, the branches of government. So
it's designed to be a counter-majoritarian institution, that's in the Federalist
I think
Papers.
I understand what that means, but can you break that down?
Sure. So it's not, the justices were given, on the Supreme Court, the U.S. Supreme Court, for example, were given lifetime appointments for a reason.
To insulate them from political pressures?
Exactly. They didn't want to be issuing decisions subject to the whim of the populace. We have elected officials for that reason. The judges were meant to impartially apply the law, and it was thought that the only way that they could do that is if they weren't subject to things like elections.
Mm-hmm. And I don't think I'm going out on a limb by suggesting that it appears, probably to lay people too, which perhaps especially so, that the judiciary has become, well, it's become turf for political conflict in a lot of ways. I mean, that seems to be a lot of the popular focus these days. Is that a reasonably fair comment?
I could not possibly disagree with that. I mean, each party is pushing people that they believe will be on the court and carry out their political agenda. And we've heard the judges over and over say, no, I will not do that. And yet, I always thought the telltale sign of judicial independence is if, when I make my argument to you and your colleagues, I can't tell in advance what the outcome is going to be based upon knowing you and your colleagues. Mm-hmm. If I can predict the outcome based on your personal beliefs, that's wrong. Mm-hmm. Mm-hmm. And I think we've moved in that direction, the latter direction.
And this is maybe a whole different issue, which we might not want to get too far into because we've got other stuff to address, but are there, as appellate lawyers and people who are attuned to the value of the independence of the judiciary, I presume there are movements and ideas about how that can be improved in some way, hopefully, I'd imagine. Lawyers who are concerned about judicial independence have some hope for improving it, or is that
it's thorny territory. There's proposals to expand the court, which sometimes referred to as court packing. Mm-hmm. There's proposals to have term limits for judges and to stagger those terms. There's a lot of proposals, and there are good arguments on both sides of those arguments of those positions. Okay,
so we'll switch gears a little bit here, and we'll get more into sort of the nuts and bolts. Can you talk a little bit about jurisdiction in terms of what cases the United States Supreme Court hears? Because there are countless numbers, and they only select a very limited batch every term. And go ahead.
About 2%, I think.
Is it that high?
Yeah, I think so. And it turns out, like anything else with statistics, it depends which statistics you look at.
Right.
But if you look at petitions for leave to appeal, the document you use, or petitions for cert, the document you use to get into the court, if lawyers are involved, I've read it's about 5% at this point, because a lot of these are pro se, people filing by themselves, and those just don't have a good chance. Mm-hmm.
It's about 7,000 a year, roughly.
Yeah. Mm-hmm. And the percentage, the number they've taken has just dropped drastically. What is it, right? Around 70 cases a year?
Yeah.
It's very, very low, lowest ever.
Just a couple decades ago, it was more than double that.
Mm-hmm. And no one knows why. I mean, one guess is that people don't want to, judges don't want to vote for accepting review of a case where they think that if we accept review of the case, the outcome will not be the outcome that I want on the case if I vote for it. It takes 4 judges. There's 9 judges on the U.S. Supreme Court. It takes 4 votes for them to agree to take a case. You need 5 votes to have an opinion on the case.
Right. Mm-hmm.
So if I persuade 4 people, if I persuade 3 other people to join me and we take the case, and I have an idea of the outcome in mind, but the other 5 people don't like it, I'm probably not going to vote to take the case. Mm-hmm. And it's a dynamic that I understand is pretty operative.
And to your question about jurisdiction, the court generally hears matters that fall under federal law regarding federal statutes, the federal constitution, violations of those. There's a small sliver of cases that deal with what's called the court's original jurisdiction. Those are cases that usually involve states somehow. The federal government's suing a state, a state suing another state, a state suing an individual in another state, and then cases involving like foreign ministers and consuls, things like that. But those are a very small percentage of the court's business.
I think some of those arose out of the border between Kentucky and Illinois, where the line is and where you can fish. I mean, little matters like that lead to the U.S. Supreme Court jurisdiction.
That's right.
Sure.
You know,
Can you spend a little time talking about the concept of judicial review, which I think as people spend, I know there's a footnote in Marbury versus Madison, which I recall spending weeks on in a con law class, although I can't tell you much more about it than we spent a lot of time on it. So I know it's maybe a heady issue, but can you provide a little bit of background on the concept of judicial review? Or maybe it's a simple one, depending on how you look at it.
It's not in the Constitution. It was Marbury versus Madison was the first case where it was articulated officially, let's say. It was a concept that had been discussed by the founding fathers. Some were for, some were against, but the basic idea is that it is the duty of the judiciary to say what the law is, to interpret the law. And that comes with it the power to strike down laws that the court deemed unconstitutional.
which probably was one of the most significant things to come out because it fleshed out Article 3. It added to Article 3 the things that the founders didn't put there.
Right.
I mean,
The Supreme Court was toothless before that.
they could issue decisions, but
President Jackson famously said, a case coming out of Georgia, I think, with the removal of Native Americans, he said, Justice Marshall issued his decision, now let him enforce it.
they had no ability, which seems remarkable to most people. Why would you be a court if you can't do anything? Well, until Marbury versus Madison, that was the case. That gave them the right to review statutes and presidential actions. As we've seen, the courts have reviewed a lot of things that Trump and Biden have both done and said they're right or wrong.
Yeah.
So not to oversimplify it, but would it be reasonably accurate to suggest that the concept of judicial review or that power is something that actually helps make the Supreme Court co-equal with the other branches, or at least contributes to a robust checks and balances system?
I'd say there were no checks and balances before that decision was issued.
Yeah, the home plate was unguarded before that. Just put a catcher in front of home plate. To now let somebody run roughshod over the thing. They have to follow the rules along the way. They just couldn't barrel down the baseline and take the plate. They had to wait till the pitch came through.
Sure. Speaking about rules, let's get into, and I know, John, you had a very recent experience advocating in the U.S. Supreme Court, which is just based on what we've heard there. Not a lot of people get an opportunity to do that. Procedures, rules, briefs, we don't have to go through everything, but can you give us a little bit of, sort of the general ideas, like what's it like, which is somewhat subjective, but what's the prep like? What are the rules? What is an attorney getting into when he or she prepares to advocate in the United States Supreme Court? And I know that's a big question, so we can break it down.
Well, my first reaction would be it's not all that different than arguing in any other appellate court. You have a period of, someone has to petition the court to hear the case. If the court decides to hear the case, you have briefing. Each side gets their say on paper as to what their position is. And then you go and you argue it in front of the court. That's really the nuts and bolts of it. My experience was a little interesting or a little different because of COVID. You had to do things like test the day before the argument, otherwise you wouldn't be allowed in the building. Courtroom.
And you passed, obviously.
I passed, thankfully. I lived like a monk for the weeks before and was sitting on the plane, just please don't get COVID, please don't get COVID. The public was not allowed in the courtroom, which is something that's new. The court's kind of famous for not allowing cameras, but they live stream the arguments now, which is an innovation, I think, good for the court. The room is meant to be and is very impressive. I'd say the court's come a long way from sitting in Congress's basement. But the thing that really struck me the most about the experience was just how close you are to the justices. Council table, they moved it a few feet back since the pandemic began.
Oh.
But council table is still within a matter of feet from the justices. You are closer. When you're sitting at the podium, you are closer to most of the justices than some of them are to each other.
Oh, yeah.
It's a strikingly intimate experience.
It's very different. All the other courtrooms in the country that we have both seen, it's august. They keep you apart. It's almost like going to some religious experience. You are up there and you're elevated, and I'm supposed to approach you. May I please speak with you? Supreme Court, right? When you stand up, you're right there.
You're right there.
I was told, if it's an afternoon argument, don't have anything with garlic for lunch. You will offend the chief judge. That was like, and it's 9 judges, if you think, they're stretched way out. If somebody on the end asks you a question, you just have to go like that.
And the bench is a semicircle, so you're right in the middle of it.
Right.
But it was much less formal than I imagined. I always imagined it being a super formal experience. With the COVID testing and everything, the clerk of the court gave me his cell phone number and just said, call me with the results when you get them.
Right.
It's
Sure.
even in the Seventh Circuit, the federal reviewing court that sits here in Chicago, it's a much more formal thing.
Mm-hmm.
I think once your case is in, they treat you almost like you're part of a club.
That's
In
perfect
some
way
way,
of putting it.
really. It's very. You need some help, they'll give you help.
Yeah.
If you need to ask where the men's room is, which is a secret, I gather, because it's hard to find unless you get Stern's book. They'll guide you. It's an important thing if you're going to argue there. But it's a good experience. But I think the difference is these cases have percolated up. Each judge has multiple law clerks. It's been briefed and memoed to death. There are amicus briefs that have been filed to help the court. They pretty much know where they're headed, I think. I asked a national correspondent once on the Supreme Court. He said, I asked, does oral argument matter there? Before I got the question out, he said no.
Really?
Yeah. Which
I'm kind of surprised to hear.
Judge Posner, who sat in the Seventh Circuit for years, answered that question twice for me, once when he started and once near when he got done, and both times the answer was the same. He said, it only matters if you tell us something we didn't know.
Right.
It's often said you're not going to win a case at oral argument, but you can lose a case at oral argument.
Yeah.
Yeah.
And it will shape the opinion. I think everybody agrees you might shape it, but it might change a strike into a ball or a ball into a strike. But the bottom line is at the end of the batting, you're either safe or out. I mean, that is predetermined somehow.
Sounds like there may be a lot of baseball analogies and metaphors used in the Supreme Court, perhaps appellate, just in general, or law.
I'm a metaphor fan. It clarifies things in my mind.
So in terms of cases getting there, you mentioned a petition for
certiorari.
Certiorari. And that's a request to be heard by the court. It's granted on not frequently granted, correct?
Correct.
And I think we've established that already. And if it is granted, then briefs are submitted, writings, papers.
Just to give you an idea of the filtering process that goes on, there's, I think, roughly 400,000 cases that are filed every year in federal court. Mm-hmm. As Mike said earlier, only 70 of those will make it up to the U.S. Supreme Court.
Sure. And state cases can get there if it involves a federal or constitutional issue too, right?
Yeah, I think that makes up it's like less than 10% of the call involves state court decisions, either state Supreme or state appellate courts, where the federal Constitution comes into play.
Mm-hmm. So once the court agrees to hear the case, then the parties submit writings or briefs that the court and their clerks will read and kind of get ready for the oral argument, right? Mm-hmm. And the justices will not interrupt rudely, maybe sometimes, but they'll interrupt the argument to ask questions of particular concern to them, correct?
It depends what you mean by rude. If it means...
Well, I was kind of making a little bit of a joke, but go ahead.
Chief Justice, my name is John Emerle, and counsel, before you begin, I want to ask you this.
I had a question once before I even introduced myself. I was walking up to the podium, and I got a question. That was my first oral argument ever. That was a rude introduction to the practice.
Okay, so it's not out of line for me to joke about the interruptions, feeling a little bit.
But I think
that.
the word interruption doesn't quite fit because
Okay,
it's
good.
meant to be a discussion.
Right.
And you are there to answer the justice's
Sure.
questions. Now, sometimes those questions are phrased more aggressively,
Right.
but that is the purpose of oral argument.
Sure. It's and for them to focus in on issues of particular concern that may impact the way they feel about the case more broadly.
That's right. What I think about the case doesn't matter. What you as the judge think about the case is what's clear. And unless you ask me something, I can talk for 30 minutes in the U.S. Supreme Court if I just sat there. I might not ever address your concerns. And that's not going to help.
Right.
And there's nothing worse than that, just getting up and hearing the sound of your own voice. I know plenty of lawyers would enjoy that, but I think most appellate practitioners would not. You get up there, you want that conversation, you invite that conversation.
And that's kind of your opportunity to really speak to the justice about the issue or series of issues that he or she considers to be critical to the decision, right?
If you can, at that level, I say so much of it has been pre-decided. It's still possible, I think, like in the state courts, you can answer a question sometime and it'll another question, and all of a sudden you'll see a judge going down a different path in their mind than they were in the first place. So you can actually change somebody's mind once in a while.
Yeah, because they're, even with elected judges, it's not as politicized at the state level.
Right.
Yeah, that's a fair statement. I think that's good. I think at least our state, there are Republican judges and Democratic judges, and frankly, I've been comfortable in appearing before all of them.
Sure.
Yeah, I think every time you're in front of the Illinois Supreme Court, you're going to get a fair shake.
Yeah.
Right. Good. So we're a little tight on time now, but I wanted to ask a quick question, or see if you could provide a somewhat quick answer to the issue of opinions. How does the court reach an opinion? How does the court decide a case?
The vote comes not necessarily in the U.S. Supreme, not necessarily after the oral argument, very shortly after, and if I remember, the chief judge assigns an author.
If the chief justice,
Yes.
so they meet every Friday. The term runs from October to June, and they have sessions, 2-week sessions, where they sit within that period of time. And at each Friday after the session ends, they take an impression vote to see how they're splitting, if they're splitting, and if the chief justice is in the majority, he will assign the case to. He gets to decide who writes it. And if the chief justice is not in the majority, then the most senior judge who is in the majority gets to assign the case.
Got it. All right. Well, this was just some foundation for the U.S. Supreme Court. We've got another group that's going to come in soon and get into details on the Dobbs versus Jackson Women's Health anticipated opinion. So, Michael, John, thank you very much for being on this installment of You and the Law. We really appreciate your time, your insight, and to our viewers, thank you very much for tuning in.
Pleasure.
Thank you.
When you need a lawyer, how do you find the right one? Contact the Chicago Bar Association.
Whether you've been injured or need a will prepared, whether you're buying a home or starting a business, having the right lawyer is essential. The Chicago Bar Association have lawyers who practice in most areas of law and speak a variety of languages.
Don't leave it to chance. Get a referral to a screened, experienced lawyer. Visit chicagobar.org or call 312-554-2001. The Chicago Bar Association. Se habla español.